Assalamualaikum everyone. So hi, my name is Shakir Zarif Randi, and for today we have Sir Amer Hamzah Arshad. Okay, Amer Hamzah Arshad read law at University of Leeds, United Kingdom. His areas of practice covered both criminal and civil litigation. His criminal law practice is focused on defense work and appeals at the High Court of Malaya, the Court of Appeal, and Federal Court of Malaysia. Amer has been involved in several landmark criminal trials and appeals, which were widely covered by media and highlighted in law journals. And he also has vast experience in a few areas, for example, commercial crime cases, corruption cases, capital punishment cases, drug offense, sexual offense, offense against public order, offense relating to national security, and immigration cases. And with that, I would like to give the floor to Mr. Amer Hamzah.
Okay, thank you, Azwan Shakir. And I would like to welcome everyone for this session and giving me this opportunity to share my experience or even to answer questions from participants or from the moderator. I understand that all of you are involved in a debate competition, which is good. And I hope that whatever sharing that we have today will assist all of you in your preparation for the debate competition. I've been made to understand that the format of today's session is in a Q&A form whereby questions can be posed, and I'm ready to answer any form of questions. I've been made to understand from the moderator that there are few key topics that would be the subject of today's discussion. But apart from that, if you have any other questions, you can just ask me, even not within the topics that we're supposed to discuss.
Yeah. So I think like to get the ball rolling, the first question that we have is when we talk about law systems around the world, there's this talk about common law systems versus civil law systems. So can you tell us a bit about the characteristics and the difference between those systems?
Okay, the term common law derives from UK. We essentially inherited the system from the British because we were colonized by the British. In Malaysia, post-Merdeka, we have our federal constitution. The federal constitution is the supreme law of the land. So when we talk about what is the main, the most important, the main law in Malaysia would have to be the federal constitution. In the federal constitution, it sets out clearly that Parliament can legislate laws in Malaysia. So in Malaysia, we have sets of law which will be legislated. It becomes Act of Parliament. Now that is known as statutes. Apart from statutes, we also have common law. Essentially, common law essentially is law that is made by judges. In certain cases where there is no specific statute to cover certain legal issues, judges will deliberate and make judgment on that particular issue. Now, whatever pronouncement made by judges on issues which are not covered by statutes, they are known as common law, judge-made law. So in Malaysia, we have that kind of, I would say, hybrid. We have the civil law system, we have a common law system. So in terms of when we talk about common law essentially means, because in UK, you have to understand that in UK, UK doesn't have a written constitution. Unlike Malaysia, we have a written constitution. UK doesn't have a written constitution. And if you trace that the legal history in UK, judges, courts have made laws. These laws that were made by judges become precedent, or we call it judicial precedent. And I think that precedent becomes a common law. So in Malaysia, we also accept common laws from UK. These are basically laws, like I said, not covered by statutes, but in Malaysia, if you look into the Federal Constitution's Article 160, for example, it has a definition of law. What constitutes law in Malaysia? Law would be acts of parliament, statutes, common law, and even common law from UK before independence can be accepted and can be referred to as a source in Malaysia. But if you talk about in terms of the system, how it works, that we have courts, we have parties, we have two opposing parties who argue before court, and then the court will make a decision. So in that context, our system is more of a adversarial system as opposed to inquisitorial. In certain jurisdiction, you have inquisitorial system, like in France, for example, where the magistrate will inquire and investigate, can pose certain questions and make a finding, apart from having lawyers represent or appearing before the magistrate or before the court. In Malaysia, the judges are more like umpires or arbiters. They will be referees for that matter. So both competing parties will argue, just like in a debate competition, you have like both sides putting forward their arguments, presenting their facts and evidence. Then the judge will decide as to which party will succeed and which party will not.
Okay, so like talking about criminal proceedings, I'm reminded of the case about the UPNM student that was abused, because I think there was a lot of confusion when people read the news, because how criminal proceedings work, they don't know why after the first phase of like lawyers arguing the case, then there's another phase. Because from what I understand is like during the first phase, lawyers for the victims will present the facts, and then they will do something where they enter defense. Can you elaborate on that?
It's a bit okay. It's nice that you pick up UPNM case. I don't know whether because you've been following that case, because I happen to be representing the first and the second accused in the UPNM case. Let's understand the criminal justice system in Malaysia. Prosecution in Malaysia can only be done by the public prosecutor, who is the Attorney General of Malaysia. Under the public prosecutor, you have a number of deputy public prosecutors. We call them DPPs. So the day-to-day prosecution in the Malaysian courts, in the Malaysian criminal courts, are done by deputy public prosecutors or DPPs. Unlike in UK, a barrister can either be for the prosecution or they can be for the defense. In UK, they do have a director of public prosecution, which is just an institution that acts to look at the case and the evidence, and then they will source out the file to a barrister to prosecute. So they do not have a special agency like our Aegis Chambers, Jabatan Peguam Negara. So in Malaysia, you are either a DPP, that means you join the Aegis Chambers, or you be a private practitioner, that means you can only be a defense lawyer. In certain cases, limited cases, a private practitioner can also prosecute, provided you have a fiat. A fiat is just a term that is like an authorization for you to prosecute on behalf of the public prosecutor. I think a clear example would be the case of involving Datuk Sri Najib Razak, whereby they engage private practitioner to assist the Aegis Chambers to prosecute. So they have a fiat. But generally, if you are private practitioner, you can only be defense counsel. So for me, I'm not with the Aegis Chambers. I've been practicing on my own. So I can only act as a defense counsel. So we understand the players. Okay, these are the players in the criminal justice system. So you have the DPP, you have the defense counsel, and then you have the judge. How it works in the criminal trial is that the prosecutor, the DPP, will always start by presenting evidence, by calling witnesses. Okay, so they will have to prove what we call it a prima facie case. So assuming that in order to establish a prima facie case for the offense of murder, they have 10 witnesses. So the DPP will have to call these 10 witnesses to give evidence. Now, every witness that takes the stand will be questioned in chief. We call it examination in chief by the DPP, the person who's calling the witness. Then the opposing party, the defense counsel, will have an opportunity to cross-examine, to test the veracity of the evidence testified by the witness. Then the prosecution can re-examine to repair any damage done during the process of cross-examination. So after you've completed calling all the relevant witnesses, there will be, we call it an argument or a submission before the judge whether a prima facie case has been established. A prima facie case in layman's terms means that the evidence is strong enough that if the accused elects to remain silent, the judge is confident that I can convict that person. So what is essentially means that we need to produce sufficient evidence to prove that there is an offense. So this is the first stage. We call it the prosecution stage or the prima facie stage, whereby the DPP will have to call witnesses, adduce evidence to establish that there is a prima facie case. And of course, the defense, through the cross-examination process, will try to demolish or to create what we call it a reasonable doubt and say that there is no prima facie case. We can argue that the elements of the offense have not been established beyond reasonable doubt. There is some glaring gap in the person's case, therefore there is no prima facie case. The judge will have to decide whether there is a prima facie case. If there is a prima facie case, it doesn't mean that the accused is guilty, because the trial is not complete yet, but it is only complete as far as the prosecution's case is concerned. But as far as the trial as a whole, it is not over yet. Now, if the judge at that stage, after hearing the arguments from both sides saying that there is no prima facie case, that means the prosecution had failed to establish a prima facie case, then the accused can be acquitted. But if the judge is of the view that the evidence adduced by the prosecution is sufficient, it meets the threshold, it meets the test, therefore there is a prima facie case, then the judge will then order the accused to enter his defense. There are three options. You can either give evidence from the witness docs, that means the accused will be subjected to cross-examination by the DPP. He can give statement, unsworn statement from the accused doc, kandang pesalah we call it, or he can elect to remain silent. So these are the three legal options that are available to an accused person once the court has decided that there is a prima facie case. Then the accused will have to give his evidence, give his version. If he has witnesses, he has to call his witnesses to support his defense. Then at the end of after the conclusion of the defense case, the judge will have to decide again as a whole whether the case has been established beyond reasonable doubt. If there is a reasonable doubt, then the accused is entitled to an acquittal. So I think that's why, in a way, you're right. We said there are two stages. First, the prosecution will have to call their witnesses. If the court satisfied that there is a prima facie case, then the defense will call their witnesses to give evidence.
So, like when talking about reasonable doubt, does that mean the defense team proves that their client is totally innocent, or does that mean that it's sufficient to prove that they could not have done the acts? Because a lot of people in the public, they misunderstood when a news reports a case has been proven as having reasonable doubt as equal to being innocent. Is that true? Or so what do we mean by reasonable doubt?
Legally, I mean, innocence is different. Innocence is different compared to being able to raise reasonable doubt. Innocence has a higher threshold because what we are required to establish that there is a reasonable doubt. We are not required to prove the innocence of the accused person. Innocence requires that I actually didn't do it, for example. I mean, I honestly didn't do it. But a reasonable doubt goes back to the golden thread in our criminal justice system, which is the accused, the prosecution must establish the case beyond a reasonable doubt. So assuming that this is the threshold for you to establish reasonable doubt, all that and if you cannot meet this threshold, you cannot convict someone. So what the defense has to do is just to show that the case could not reach this level. It is only up to this level. So there is a gap. There is a reasonable doubt there. So that's what we are required to do under the law. So to lay a person, and of course, maybe some individuals would say that I've been acquitted, therefore I'm innocent. I wouldn't say that person is entirely incorrect. In a way, of course, if you've been acquitted, you would definitely say that I'm innocent. But from a legal standpoint, we rarely use that term, he's innocent. It is more for political purposes, for political expediences, I'm innocent. But for the legal point of view, of course, there's nothing stopping from the defense to establish that he's actually innocent, that he didn't commit the offense. If you're able to do that, well and good. I mean, if you have facts, evidence to really show that he's innocent, there's nothing stopping the defense from establishing that. But all you are required under the law is to raise reasonable doubt, which is a slightly lower threshold. So yes, there is a slight difference between innocent, being totally innocent, and being able to raise reasonable doubt.
Yeah, thank you. So like a reminder to our participants, if you have any questions, you can enter your questions in the chat at any point, and I'll pick them up and ask them towards the speaker. So going back to the UPNM case, like I use that example because it's a very publicized criminal trial and hopefully something that our participants would have heard of in the news. So we heard a lot of, or even not the UPNM case, like in very publicized trials such as the one NDB case, when there's a lot, the people involved in the trial will use the term contempt of the court when asked to comment on the case. So can you like elaborate what is it meant? What does it mean to be in contempt of the court? Like, can you not comment on the case publicly, or because obviously like in certain cases, like the public has an interest to know about it from the news, but what can or can you not say about it during the trial?
Okay, contempt of court is actually a wide concept. In simple terms, like menghina mahkamah, is like menghina the institution. It can be committed not just by commenting certain ongoing case. That is a subspecies of contempt, sub judice. Contempt in generally means that you are not giving the due respect to the court by way of your words or conduct. It can be done in the face of the court or outside court. In the face of the court, for example, like because you disagree with the judge, you say like you are stupid, you idiot. That is contempt in the face of the court. You have no disrespect to the institution. You have no disrespect to the judge who's presiding over the matter. Let's not forget whether you are for the prosecution, whether you're for the plaintiff or you're for the defendant or you're for the defense. All of us are officers of the court, so you need to give respect to the court. And the judge, whoever is sitting there, is just doing his duty. So if you disagree, we have a channel. You can always appeal. So to use certain vulgarities or inappropriate words in court, that is not acceptable. That could also be a contempt of court. Now, outside court, for example, if a decision is not in your favor and you decided to criticize the judge by saying, and there's a press conference that this judge is stupid. I mean, he didn't know what he's doing. I mean, he's totally wrong. I mean, he got it all wrong. He's an idiot. Yeah, you make that kind of statement to the press outside court. That is also contempt of court, even though it was not committed in court, but it is still contempt to the institution of the judiciary. Or you publish an article commenting on the outcome of the case and saying that, oh, the judge has been bribed, the judge is corrupted. That is also contempt. Now, that kind of contempt is, like I said, you're just disrespecting the institution. Now, what you're trying to ask, if I understand it correctly, is what I explained just now, sub judice. That means a person should not comment on an ongoing court proceeding so that it may, for fear that it may influence the outcome of the case. Now, we have to understand, back then when we had jury trials where the jury will be the party that decides on on the outcome of the case. The judge is just to guide the jury, say these are the points of law, this evidence can be used, this evidence cannot be used, this cannot be admitted. So you need to confine yourself to this evidence and you decide on the facts. So jury back then are the trier of facts. Now, jury being non-legally trained could be influenced by what they read in the news. So that's why we had this concept of subject. You should not be discussing anything publicly with the jury, for example, so that they may be influenced by what's been reported in the media. But in Malaysia, we have no longer jury trial. We have trial by a sitting judge. A judge is a legally trained individual, a professional, so they would not be easily influenced by what's been reported outside. So this whole concept of sub judice or contempt of court, I don't think it is really relevant in the present context. But because the concept is there, so people tend to use it because they do not want to comment something, or they want to prevent public from discussing over that issue. But let's be clear, if you want, for the public, if you really want to comment or to give opinion on a certain ongoing court proceedings, we first and foremost must be clear. Do we have all the relevant facts? Do we know what actually goes on in court? So it is not appropriate. I will use the word appropriate, not say it is wrong. I would say it's not appropriate for you to comment on something when you do not possess or have the full facts, the full feature, and you're giving your opinion. An opinion without supporting facts is just sembang kosong kat tepi warung lah. It doesn't have any value. So even for lawyers, if you want to comment on certain issues, you must make sure that what are the facts, what are the issues, then you comment. Let's not comment into the facts of the trial, because we are not the parties who have the full picture of what actually transpired in court. The news reporting will not give you an accurate, a complete picture of what normally happens in court. They will try to pick the juicy parts of the proceeding so that they will gain more readers and they will gain more reaction from the public. That's what normally media does.
I see. So that's very interesting. And I remembered something from our discussion before the session where you said something along the lines of justice must not only be done but be seen. And that made me think about like the death penalty, because there has been a lot of push or movement for Malaysia or even like in other countries to abolish the death penalty. So do you think that the death penalty has been an effective deterrence in murder cases, for example? Or is it something yang not effective and cruel? Or generally, what's your take on it?
Well, personally, I'm against death penalty. Of course, this is an whole debate. I mean, like since time immemorial, people have been debating whether we should have death penalty. In other jurisdictions, they have. In most countries, they have abolished death penalty. In US, only limited to certain states where they still have death penalty. UK doesn't have death penalty anymore. In Malaysia, we do have death penalty, but it is limited to certain offences. Certain offences, the judge still has a discretion to decide whether to impose death penalty or otherwise. In limited offences, there is no discretion given to the judge. I think two clear offences where the judge does not have the discretion would be murder and drug trafficking. So these are what we call it mandatory death penalty. Now, whether it first and foremost, we have to understand what is the underlying principle or the philosophy for sentencing. When we sentence, what is the objective that we would like to achieve? Is it because we want some sort of retribution? Or are we sentencing an offender because we want to rehabilitate the said individual? Or is it because we believe in this eye for an eye? Hutang darah dibayar darah. Is that what we believe? That if you committed, we need to punish you, deserve you? So what is our understanding? What is our philosophy when it comes to sentencing? Now, I personally believe that when it comes to sentencing, we must always adopt the rehabilitative principle. So when someone committed an offense, he did something wrong. We as a society should put in an effort and try to correct the said individual and give him a chance so that he can come back to the society and be someone who is useful. So that is my understanding. That is the philosophy that I believe in. I believe in second chances. Being a student of ANSARA TEPEN, bukanlah selalunya kita baik, kadang-kadang kita ada masalah. So if I never had that second opportunity, maybe I will not be the person who I am today. Okay, so let's not disregard the impact of giving second chances to offenders. So if you implement death penalty, will there be any second chances? There won't be any second chances because the person is already dead. You already hanged that person. And whether that would be a deterrent, I think there are a lot of studies being done all over the world. It clearly shows that death penalty does not act as a deterrent. Let me give you an example for drug trafficking. I mean, we have the reason why, because it's a national policy, we do not tolerate drug. But if you look at the number of drug traffickers who are being charged in court, these are not the drug laws. These are not the cartels. These are just the small fry. These are just a small time drug peddler who happens to be in possession of a certain weight of drugs. I'll give you an example. For cannabis, if you are in possession of more than 200 grams of cannabis, you will be presumed to be trafficking. So let's look at that quantum. Slightly more than 200, you are presumed to be trafficking. This is totally different compared to the drug lord who actually controls the drug business. So you are actually arresting and trying to sentence someone who would be just a person who has no proper job, selling slightly more than 200 grams of cannabis to the gallows because the law says so and the judge has no discretion. Does it deter? It doesn't. It doesn't. Now, for the offense of murder, of course, it is a very sensitive, emotional debate. When you ask to the victims of family members of the victims, they will say, no, that person deserved to die because he took a life of my family member or my son or my child. Of course, we understand that something has to be done. I mean, if a person is found guilty, the person has to be punished. But by taking away another person's life, are we sending the right message? If we, on one hand, believe that taking away someone's life is wrong morally, why are we saying that a state can take someone's life? I mean, two wrongs don't make a right. If you look in Scandinavia, if you do some research in the Scandinavian countries, Norway, Sweden, for example, there have been a series of, I know of that few cases whereby young offenders committed murder, but they were not sentenced to death. They were in prison. Of course, they had to be punished for the offense that they committed, but they were allowed to go back to society, and now they're just being part of society. They are helping the society. They are contributing to the music industry, for example. I've been following some individuals who have been sentenced to death, who committed murder in Norway, for example. So here, if someone who has been convicted and sentenced to death, there will not be any second chance. Now, let's not forget, in our criminal justice system, it is not a perfect system. It is a man-made system. No man-made system is perfect. There are tendencies or possibilities that witnesses could be lying. Okay, there's a possibility that the evidence could be tampered. No, we do our best in order to eliminate lying witnesses from the process. We do our best to identify improper evidence being adduced in court. But there are certain limitations. But if the judge decides that I'm going to accept this, what can we do? We end up sending someone who may not be guilty to the gallows, and there is no recourse. Now, if you have been wrongfully convicted, but you were only imprisoned, and if subsequently new evidence emerge, you can always be released back to the society. But if you have been convicted, wrongfully convicted, and you've been sentenced to death, what are we going to do? Are we going to dig the grave, raise the dead? That can't be done. So there is this ongoing debate. But as for me, I'm totally against death penalty. That should not be accepted in any modern society.
Yeah.
Okay,
Yeah,
so
Shakib.
from your experience within the criminal legal field, do you think that the male rape victims could find solace without proper charges initiated against the perpetrator? If not, do you think that it is possible in the future that our penal code will recognize rape against male victims?
Rape against male victim. Okay, that's interesting. I think the law has not. I think society has not even recognized that concept. So for it to be an offense, it has to be something which is widely recognized, accepted in the society. Of course, your first question is about the second question I said is about male. Okay, but the first question just now, Shaki, could you please repeat?
The
When
first one,
a rape victim could find solace
without proper charges initiated against the perpetrator.
Of course, I mean, if someone who is a victim of any sexual offense, I'm not saying rape, any sexual offense, it could be molest, whatever, there will be some sort of trauma. You will definitely be affected emotionally. You will definitely be traumatized by the incident. So you definitely want justice. So one of the ways is for you to get assistance from the authorities and hope that the perpetrators will be prosecuted. However, in certain cases, maybe the evidence may not be strong enough. Maybe, for example, the incident happened quite some time ago, and you never had the courage to come forward to lodge a report. And after like few months down the line, you decided, look, I really want to have some sort of justice. I want to have some sort of closure. You lodge a report. Now, if you lodge a report, maybe few months down the line, after the incident had happened like quite some time back, most of the evidence that could be used in order to prosecute the perpetrator may not be able to be recovered. There won't be any forensic evidence to assist or to corroborate the testimony of the victim. So in that case, you may not be able to see prosecution. You may not be able to have any prosecution against the perpetrator. But having said that, there is nothing stopping the victim from filing a civil claim against the perpetrator. So in order to seek justice, there are two ways. One is by getting a prosecution against the perpetrator, whereby you need to lodge a report, the matter will have to be investigated, and the AG's chambers will have to be satisfied that there is enough evidence against the perpetrator. Alternatively, the victim can always engage a lawyer, file a civil suit, and prove the case in court. The burden of proving a civil claim in court is much lower compared to establishing a criminal case in a criminal court. In the civil courts, if you want to bring an action against anyone, you only have to prove on a balance of probabilities, which is a lower threshold. So the chances of winning or getting some sort of compensation, if that would make the victim feel better, that is another approach that can be done. Okay, so that would address your first question. What could the victim do? I mean, like if there's no prosecution, there is always this alternative for you to bring a civil suit. Of course, I mean, you want the person, but the civil suit will only give you damages, pampasan. The civil court cannot penalize the perpetrator. The civil court does not have the jurisdiction to sentence the perpetrator to jail. Let's take the case of O.J. Simpson as an example. O.J. Simpson, he was acquitted. You know, the famous word, if it doesn't fit, you must acquit, by the late Johnny Cochran. The victim, the family members of the victim were not happy because they didn't get, they felt that they didn't get justice because O.J. Simpson was acquitted. So they filed a civil suit against O.J. Simpson, and they succeeded in getting damages. So if talking about getting some sort of closure, I mean, there are always these two avenues that you can consider, the civil court and the criminal court. As to whether male can be a victim of rape, I'm not discounting that possibility, but the law as it is does not recognize male victim as a victim of rape, because the definition of rape clearly does not include male. But if a male person had been, I mean, to use the term, been sodomized, there is an offense for that. There is a separate offense which is distinct from rape. It is one of the sexual offenses in our penal code. So if you've been sodomized, delivered without your consent, you can lodge a report. Like even consensual, I mean, as it is, it is an offense. But the question is how you're going to establish unless it is recorded and there's evidence by a third party witnessing the entire incident. So sodomy, I mean, as far as the law is concerned, it is still an offense, whether with consent or without consent. So if the context of male being raped, if you referring to a situation where a male being sodomized, it is an offense. The person can lodge a report and can get justice in the criminal court, or even can file a civil suit if he wants to.
I see. I think another question that I think would be especially relevant to our participants is something about sentencing. I've seen in the news that, like you said earlier, judges are obviously human, and therefore they have their own sets of biases. So there have been like push by some groups for the justice system to use artificial intelligence in sentencing. So do you think that would like make the problem worse, or would that solve some of the more pressing issues?
Okay, when it comes to sentencing, it's not like a straightforward method. Of course, we are guided by precedents. We are guided by what is a sentencing trend. For a particular offense, we normally look at past cases and to see what is the sentencing trend. And we try to get guidelines. But having said that, every case is unique. That there is no case which is the same. So you need to look into each particular case based on the facts that are before that particular judge. You need also to remember that every accused person is different. They come from different social background, different upbringing. So these are the factors that must be taken into consideration before you sentence someone. Now, this AI, of course, it sounds very sophisticated, as if that they could come up with the most appropriate sentence. But what I've been made to understand, it is more like a database rather than an artificial intelligence kind of thing. So it's more like a database for the offense of, for example, possession of drugs. What would be the sentence? And based on the database, it will come up with this suggestion. Now, that database, or whatever system that we have, should not dictate any judge. And the judge should not be bound by that particular result from whatever system that they have implemented. It should, if at all, be used as a guide, because we still need to factor in other mitigating factors. And like I said, every case is unique, every accused person is different, therefore the mitigating factors for every person will be different. A mitigating factors are things that judges must consider before they pass sentence, except for cases where there's only one sentence, like mandatory death sentence, there is no other option for the judge. But for other cases where there is a discretion conferred to the judge, so the judge must take into account the mitigating factors, the aggravating factors, the social background of the accused person, the seriousness of the offense, the unique features of that particular case. So there are various other factors that has to be taken into consideration. So whatever system that we want to implement, whether it be an AI, a database, should only be a guide, and it should not dictate and bind the judge. So we do not want a situation where if you've been convicted for this particular offense and you key in into the system, comes up with, okay, for this offense, a person should be sentenced to say 6 years, and therefore you straight away sentence that person to 6 years. No, we should not have that kind of a system. Whatever system we want to implement, it should only be to facilitate, to assist, but not to dictate and bind the decision maker.
Mm-hmm. So when we talk about decision maker, right? So obviously in Malaysia, we don't have a jury trial system. So do you think like, but in countries such as the United States, they do have like a jury system for certain cases. So do you think like there's any advantage in having a jury system over the one that we have in Malaysia?
Okay, when it comes to jury, we have to understand jury does not deal with sentencing. Jury deals with facts. So in the US, where they still have jury system, they will only decide whether the person is guilty or not based on the facts and evidence. The sentencing is still the domain of the judge because it is a legal matter. So in jurisdiction where you have trial by jury, the role of the judge is to control or to determine the legal aspect of the trial. The jury will hear the factual evidence and decide based on the factual evidence guided by the judge. So if you ask me whether trial by jury has its advantages, I would say to a certain extent, yes. I think that's where the role of advocacy becomes very crucial. How the lawyer argues the matter. Before a trial judge, the judge will be very immune to the issues, and they may not be able to look at that particular argument in the same manner as a lay people. A lay people may be able to appreciate the background, for example, of the accused person, and therefore understand it from a different angle. And that's why in the US, the jury vetting is a key crucial process where they will try to get the best possible jury that they think they may decide in favor for either the prosecution or the defense, because they look into the demographic, the composition of the jury, the background of the jury, the education level of the jury. So there are pros and cons. In terms of pros, I think the jury will be much more sympathetic in certain cases. But the downside to a jury system is that jury can also be influenced. I mean, nowadays with the advance of social media, emotions can control and cloud the judgment of lay people. So, and that's a danger downside to that. It may not so much in the, if you look in the 80s or 90s, maybe social media wasn't widely used as it is now. Now, I mean, every day you will get some sort of opinion, views from different parties, and that may cloud your judgment in deciding a matter. So you have that risk whereby the jury can be influenced by social media and may not decide according to the facts and the law. So, and it's also costly. Let's not forget the cost of empaneling a jury is not cheap, because they have to take leave from their employment. So it has that effect to the employers, and the government will have to bear the expenses of the jury during the trial. And as you know, our trial here, well, we hope that it could finish as soon as possible within a reasonable time frame, but there are so many restrictions. Trial can take years. The UPNM case that you mentioned just now, it has been ongoing for since what, 2000, I can't remember when it started, 2018 or 19. Yeah. So it's been like how many years? So yeah, there are pros and cons about jury system. A jury can be a bit more sympathetic when it comes to deciding on whether a person is guilty or otherwise. But when it comes to sentencing, they don't play a role. When it comes to sentencing, they do not play any role whatsoever in terms of sentencing. It's only the judge.
I see.
Okay, so what are your thoughts on people waiting to lodge a report when the perpetrator is 18 years old? Is it fair for them to be held accountable for something they committed before the age of 18?
Okay, whether it's appropriate for someone to lodge a report against a person under the age of 18.
Yes.
Well, put it this way, whether you're below 18, if you committed an offense, it is still an offense. It's just that the way how you be dealt with will be different from an adult. We have the Child's Act that governs anyone below 18, how a trial involving, I use the term child, how a trial involving a child should be conducted. It is totally different from the normal process. For an adult, if you're being charged, then you will be tried in open court. But for a child, even the investigation, for example, there are certain safeguards that have been implemented in the Child's Act to ensure that the child will not be subjected to unnecessary improper treatment. And during the trial process, the public is not allowed to be present during the trial involving a child, because you need to protect the identity of the child. And the whole concept is based on this understanding that you need to give a child a second chance, because they made a mistake. It's due to lack of maturity that they may have committed this offense. So they should not be penalized. Yeah, that's why their names of juveniles are being withheld. They will not be made public, because you do not want to jeopardize their future. And if even, for example, if they ended up in one of those approved school ataupun Henry Gurney, they will not be recorded as conviction. All these child offenders, if they are found guilty, they will not be considered as being convicted. They are not convicts. Of course, there'll be a finding of guilt, but they will not be considered as convicts, so that tak ada istilah pesalah, so that they would be able to start a new life. So whether a child below the age of 18 should be subject to the normal due process, I think they have to, because anybody who commits a wrongdoing, anybody who commits an offense has to be dealt with appropriately. But how do we deal with child, those below the age of 18? There is a certain mechanism. They should be dealt with. They should be subject to due process. And if they're found to be in the wrong, then they should be given the necessary appropriate punishment. But like I said, the concept of punishment must always bear in mind the philosophy of rehabilitation, so that they will be given a chance to move on and be someone who's useful to the society.
Yeah. There's a follow-up question regarding capital punishment from one of the participants, and they ask, earlier you mentioned about capital punishment against drug traffickers, and it is widely known that Malaysia has one of the most stringent drug laws. However, the previous government proposed a non-punitive approach against drug abuse and drug trafficking, and it has raised concerns of possible increase of its abuse.
Okay, when you say non-punitive, maybe it's not quite apt to say non-punitive, because if you commit an offense, drug offense, it may be, you have to be punished. There's no two ways about it. You have to be punished. The only question is whether death penalty should be one of the punishment. As it is now, we have imprisonment, which is, if you ask me, is a far more effective deterrent. Nobody wants to be in prison, especially for a long period of time. What has been suggested, and I think what had been implemented, was a moratorium for death penalty, because they're still studying into this concept, whether they want to make it mandatory or otherwise. And as a result of that, for drug offenses in Malaysia now, they have amended it, so that there is a discretion given to the judge to not impose death penalty for drug trafficking offenses. However, there are certain conditions. And of course, whether those conditions are constitutional or not, it is still an issue which I'm still going to argue in one of my cases, whether the conditions imposed before a judge can decide whether to impose death penalty or not, whether it's constitutional, that is another legal issue. So if you ask me again, death penalty has never been effective in terms of reducing the number of cases statistically, I do not see any improvement. It doesn't really benefit anybody. In fact, it will create ancillary issues, social issues. What I can see now, and based on what I've observed, is that when a family is faced with a suspect or one of the members being executed or being sent to the gallows, there will be certain opportunists, group of opportunists being in the enforcement agency, will try to say, look, we can try to make sure that the offense is not drug trafficking. We can try to reduce the offense to possession so that he will not be subject to death penalty. But in order for us to make the sentence, the charge to be less, you need to pay us. In other way, they're asking for bribe. So there have been some talks. I mean, I've heard allegations being made that certain enforcement agencies are asking for certain money so that they can try to more or less fabricate the case or manipulate the case so that the case will not be a trafficking case, but it will be reduced to possession so that the person will escape the possibility of being sentenced to death. So it has created that kind of a polemic, a different kind of like a problem. Death penalty, I'm not saying that offenders should not be punished. They should be penalized, but they should not be executed. Okay, they should not be executed because we want to rehabilitate, we want to punish them so that they will be rehabilitated, not for them to be executed.
Yeah. So I think like obviously I don't have a formal background in law, but I think that from what I've heard is that your position is that you favor the Scandinavian model when dealing with criminals or whatnot. Do you think that such a model will be feasible to be implemented in Malaysia?
Well, we have to understand that in Norway, for example, the population is far more smaller compared to Malaysia. I don't know. Maybe, I mean, if we have the resources, having a correctional facility like those in the Scandinavian countries would be the best way forward. You will be given opportunity to reflect upon your. I believe that. Let's take a smaller example, closer to home. Kalau if budak buat salah, if our child buat salah lah, anak kita buat salah, do we take the harsh approach, pukul, punish, or do we take a different approach, trying to slow talk and trying to make them realize their mistake, let them reflect on their mistake so that they understand that while they committed something which is wrong, at the same time that there's still people who care about them, and therefore they will then change for the better? Or do we want an environment whereby we punish that person so that that person becomes so hardened, becomes so hardcore, and whatever you do to him, it's like a salah. So the system, if you look at the Southeast Asian punya prison, Thailand, for example, Indonesia, quite bad. Even Malaysia, I'm not saying it's any better, but maybe not as bad as Thailand or Indonesia. But if you put someone in a very harsh condition, that person will be a hardened criminal. I mean, you may not even like rehabilitate that person, but instead you may even turn that person into someone who's more hardened, who couldn't care less, because if nobody cares about me, nobody wants to give me a second chance, why should I be bothered? And instead of punishing and rehabilitating, you actually like turning that person into a more serious offender once he's been released from prison.
I see. I think we've dealt with very some heavy topics in the session today. So before because we're coming to an end, it's already almost 11 o'clock. But if the participants have any questions for our speaker to clarify, I will be glad to forward them. If you have any questions for our speaker before we end the session, you can put them in the chat. But if you don't, I would encourage everybody to reflect on what has been discussed today. I think it will be very helpful for you during the competition. Everything that has been discussed today is very relevant, but also not just for the competition, right? Just for you as a citizen in the country, or some of you might go on to pursue a career in law, or whatever. But yeah, so I think that's the end of our session today. If we don't have any more questions, there will be a 30-minute break, and at 11:30 we will have a session with another alumni on cryptocurrencies and financial technology. Thank you, Mr. Amer Hamzah, for the session today and a very interesting discussion.
It's my pleasure, and thank you to all of you for organizing this and giving me this opportunity to share with fellow MMSM students.
Yeah. So thank you, everyone. I'll see you again
Thank you,
at
everyone. Yeah.
Okay.
11:30.
Thank you.